Talking about medical malpractice, that's a broad topic, Sam.
It sure
Um,
is.
what are some specific medical malpractice cases that you see?
Okay, well, surgery is a hotbed. Every day in Ontario, literally hundreds of patients go through surgery, and most of them sail through. But occasionally, there is a situation in which we are concerned that the surgery was not appropriate, and that can cut across a whole series of different errors. I'm sure you've seen a lot of these.
Yes, unfortunately, some of the ones I've seen are unnecessary surgeries,
Yeah.
a pathology report read wrong, or maybe the area has changed and surgery is no longer recommended anymore, and the doctor's not kept up with it. And that's really hard for patients. Surgery, no matter what it is not easy to go through. It carries a lot of risks, can carry permanent scarring. So unnecessary surgeries are a big one and a very difficult one.
So too are those surgeries in which hardware is implanted for some reason. If it's implanted incorrectly, or if the wrong pieces are put in, it can have devastating results for the recipient and should never have been done.
Right? If surgery's performed improperly, or worse, performed improperly, and then there's no follow up or monitoring, and it just gets worse and worse.
Yep. The other type of surgery that we have dealt with in our practice is laparoscopic surgery, which is a great benefit to patients. It cuts down the hospital time immensely, but occasionally a surgeon can get lost when peeking through the scope and bad things can happen.
What about medication errors?
Yeah, boy, when a physician prescribes a medication, they're obligated to know about that medication. That means side effects, and it means what are called contraindications, patients who should not be given this kind of medication. And beyond that, they're obliged to monitor many medications. Some of them are quite dangerous if not followed correctly. You can lose, for example, potassium, which is an important chemical for heartbeat, for example.
Also, making sure that you're giving the right dosage,
Yeah.
that you're administering the medication correctly.
Yep. We've seen cases of both of those. And it's almost a first rule of medicine that when something goes wrong, check the medication list first. See if that's potentially a side effect. It's surprising how often it's missed.
Yeah, yeah. What about diagnoses?
Ooh, diagnosis is an interesting area. One area we unfortunately do see is errors in imaging reports, so that something is missed on imaging, and when it's reviewed, it's clear that something not nice was there earlier. That sort of points to the general area of delayed diagnosis.
Yeah, and I think we all can appreciate that the sooner you have a diagnosis, the better your outcome is going to be. This is especially critical for cancers.
We've seen some patients who uh, our experts tell us would not have been in the circumstances they are, but for the delay in the diagnosis.
Yeah, and we've got really good statistics now on cancers that show that the earlier you can diagnose, the better your outcome will be. And lastly, I think a big one that we see with just tragic consequences are birth injuries.
Yep, those are so difficult for the family. It's not just the mom and the child, but the entire family that are impacted and impacted quite frequently for life. Uh, that shouldn't happen. It's if in fact there has been negligence during an obstetrical event, the child needs to be compensated and given resources to cope with whatever disabilities may arise. So, Francis, when we are approached by a patient or a client about a malpractice concern, what happens? What's the process?
Yeah, I mean, the very last thing I want to do is have a patient who's had a terrible experience with the medical system have to pay us legal fees. Okay. Most of these cases that we do are on contingency. So it means that the patient does not pay us until we have a good result or until we take the case to trial and we win it. Um, but that does mean that we also don't want to give anyone false hope. So we take a really careful, serious look at the cases that come in our door.
I think that's absolutely critical. Physicians are not held to a standard of perfection. They simply have to do the very best they can, and sometimes outcomes, for no fault of anyone, just aren't as the patient would like. So we are very careful in sifting through cases and getting the ones that really do deserve compensation.
Yeah, and it's always helpful if a patient is coming to us, a potential client, that they give us as much information as they have from the outset. Timelines as to what happened, very helpful for us. The names of everyone involved, very helpful. And many people, at least in Ottawa, also have their records available to them through My Chart or other online means. And having those right from the outset, very helpful for us too. It can give us a good sense right from the beginning if this is a case that we want to give you hope we can pursue for you.
And certainly speeding up the beginning of the process is very helpful because the process, through no fault of clients or lawyers, is tends to be a lengthy one. The Speaking of time, we probably should just flag that there is a limitation on bringing your case to the attention of the courts, typically 2 years.
Our firm carefully looks at new cases that come to us. The last thing we want is to give a patient false hope that they can have a successful result. So what's your process, Sam, when a new case comes in the door?
Okay, well, the most important thing is to get records. And frequently, as you've referenced, patients may have got some records on their own. If they haven't, we can certainly give them an authorization form and request the records. And that's probably where I come in. I look at the records very carefully. I practiced medicine in this province for a long time and have a pretty good sense of what looks suspicious and what doesn't. Once I do that, we meet with the whole team. We talk about the law applicable to whatever seems to have come out of the records and whether or not there's a solid case. So I think we are able to offer a faster turnaround and a firmer decision than many other firms.
When you say you practice medicine for a long time, how long and what were you practicing?
Okay. Um, I suppose I could claim the fifth, but I'll go ahead and I'll tell you. It was almost 4 decades, and I was doing primary care, both my own practice and subsequently urgent care clinics.
Okay, so when we get in records or we get in new claims, you really do know how to go through those
Yep.
and find out what to look for.
You know what to look for. You also know what should be there and recognize if it isn't. And that's something that a lot of people who review records don't know.
Now, when we meet a client for the first time, Sam, we'll talk a lot in that first meeting about a concept called standard of care. How would you simply describe what standard of care is to someone who's never heard that term before?
Absolutely. Well, standard of care is the standard to which a normal, prudent practitioner in the specialty that we're dealing with would be held by peers in that specialty. In other words, it's a judgment by the profession itself. It's not the lawyers that are making this, it's not the courts, it's other people in the specialty.
Yeah, I've always kind of thought of it as like, what would the average doctor do in the same circumstances with all the same facts? What would that sort of average doctor do with it? And it's really easy, I think, when you've had a bad outcome to look at it with foresight and think, well, how could the doctor not have known that would happen? But that's it's not always that easy in the circumstances. And so we're always thinking, okay, what would the prudent average doctor do in the same circumstances? That's always the question that we're thinking about. And as you've alluded to, it's not really for you and I to make that determination. How do we go about proving what the standard of care is and if a doctor has fallen below it?
Well, generally, what we do is having gone through the records ourselves and had our suspicions raised, we'll formulate a list of questions that we feel need to be answered. And we will select a specialist in the same specialty as the individual that we're looking at and ask them, did this person fall below the standard of care? And can you respond to the questions that we've supplied you? Over time, I think we've built up a group of experts that we feel very comfortable consulting and whose opinions, measured against the contrary opinions that we encounter, are always very strong.
It's true, but there are some cases, rarely, but sometimes there are cases where the negligence or the failure to meet the standard of care is obvious on the face of it. So there was a case, not our case, but there was a case where the Supreme Court said, if you count the sponges going into the patient and you count the sponges coming out, and if you've left behind a sponge, I don't need an expert to tell me that that was wrong.
Absolutely. That situation is accessible to the common sense of the court.
At a first meeting, we'll also talk a lot about a concept called causation. And this is one of the more complex areas of medical malpractice cases. And it basically means that we have to show that even if a doctor fell below the standard of care, didn't do something that they were supposed to do, that caused the person's bad outcome.
Yeah, causation gives rise to great debate in negligence cases, particularly because, and I'm not going to go into this, there are two types of causation, legal and factual. But we have to establish that the negligence that we have identified was in fact the cause of the injury. If a patient was desperately ill and about to expire, a mistake in a drug dose might not be deemed to have been causative and the action would not go forward. Fortunately, I think we've been very assiduous at making clear our cases that have raised causation issues.
Yeah, I think that when a doctor has fallen below the standard of care in our view, we've gotten very good, very determined at being able to prove that failure did cause the patient's bad outcome. And certainly when we feel an error is made, it's an area we will pursue as ardently as possible.
Yeah. We've talked a lot in the past about causation, standard of care, but at the end of the day, in some ways, this is all about damages. How does the patient get compensated? What's your experience with damages in medical malpractice cases?
Yeah, there's a few heads of damages that we go to. First and foremost, there's what we call your general damages for your pain, suffering, your loss of enjoyment of life. Gosh, these are subjective. They're difficult to quantify. You line up 100 judges, and they'll give you 100 different answers. One way that I think medical malpractice damages are unique is the breach of trust that a patient feels after they've had a bad encounter with the medical system. When you think about who you trust in life, I think doctors rate really, really highly on that list. And if something is wrong with you, you are really placing tremendous trust in your doctor and in the medical system to help you to figure out what's going wrong, maybe to save your life. And when that falls apart, it can be really shattering
Yeah.
to feel like you can't trust the medical system and you start thinking, no, if I can't trust my doctor, who can I trust in life?
Yeah, it would be a tragedy if a negligent act forced patients away from the medical care system. Most of the time, the care is pretty good. But you've mentioned general damages. I find that patients or clients are frequently surprised to learn that those general damages are capped.
Yes, that's right. In Canada in the 1970s, our Supreme Court said they can't be higher than $100,000. Now, that's gone up with time. Now we're looking at about 450,000, 460,000 with inflation. Um, and I think really the reason behind it is that if you could truly compensate someone for the pain and suffering they've gone through, there wouldn't be a big enough number to satisfy it.
Translating suffering into dollars is doomed to failure at the start. We just do the best we can. And often the clients are extremely gratified at the results.
Yeah.
What about other heads of damages besides the the general damages.
Yeah, there's income losses. So if you're unable to go back to work because of what's happened to you, we can look at what you were doing before the event. We can try and project what you would have done in your career, how long you would have worked for, and when you most likely would have retired, and do a projection as to what your lost income is. We can also look at the types of care that you might need now and in the future. Look, a lot of things are covered by OHIP, but there's also a lot of things that aren't. Just even things like travel to appointments, mileage, parking, and then if you need specialties like physios or, say, caregivers, PSW care, all of that can get really expensive over the course of your life.
Yeah, and unfortunately, malpractice doesn't just impact the client. The suffering and disability the client may have impacts the client's family. Unfortunately, they too can claim damages.
That's right. They can claim damages for the loss of the relationship that they had with the person, and they can also claim damages if they're now providing that nursing care.
Many families feel awkward about that notion, but if they weren't doing it, a personal service worker would be required. There's no reason why they shouldn't be compensated, and the courts have been clear on this.
As a physician for many years and now as a lawyer with us, how do you involve client in their case and make them feel part of the outcome?
Well, that's a really good question. And I think the best answer I can give you is communicating right from the start to make sure we're both on the same track. This means explaining my thought process in response to the problem that they have brought to the office. They need to understand uh, what's going to happen going forward. They need to understand that we're not doing this alone. We're doing it for them and require their instructions for each step of the way to make sure that we're both on the same page. It's not unlike so-called shared decision making in medicine, where patients increasingly are being presented with various alternatives, risks and benefits discussed, and then the doctor and the patient come to a conclusion together as to how they'll go forward. So we try and make the process really transparent. Uh, Part of that involves not using big words that can be simplified. For example, discovery. What's discovery? Well, we'll define that. We'll explain what that is. Pre-trial conference. What's that involve? Mediation. What do we mean by that? One of the mechanisms we've used, we've put an infographic up on our website that literally starts from the day you walk into the office. What should you expect as you go along? And at what points in that process can the case be settled? And how long is it going to take? And hopefully, being transparent about that kind of thing will simplify a process that seems long and tedious to clients, uh, but the steps are necessary. So I think back to my original point, communication and a shared understanding of what we're doing and how we're doing it is the basis of practicing good law, just like it's the basis for good medicine.
Yeah, I agree. I think it's really important to make sure that our clients feel involved in the process and that they know where we're going and what happens along each stage of the proceeding.